Tantor Audio, a division of Recorded Books, presents Elegant Legal Writing by Mccarl, narrated by Shawn Compton. Publisher's note: this audiobook includes bonus material. Please visit tantor.com and type Elegant Legal Writing into the search box. Follow the link to the book's page. Then, under the Supplemental Content section, please enter the access code BRIEF, and then click the Unlock button to access the bonus material. The code should be entered in all lowercase letters. All tables referenced in this audiobook can be found in the bonus material. Introduction. Writing briefs that persuade and impress judges is no easy task. Most judges are overwhelmed with work and can't afford to spend more time than needed with the filings that cross their desks. But a client's litigation goals often depend on their attorney's ability to get a judge's attention and make concise, compelling arguments. Reading legal documents should be painless. Upon opening a litigation brief, a judge should be able to immediately perceive its main arguments, then experience a sense of relief upon discovering that it includes a lucid, accurate, and easy-to-follow explanation of the relevant facts and law. 3 core principles underlie elegant legal writing. 1. Readability. Judges and clients have limited time, attention span, and motivation to read legal documents. Attorneys should therefore cultivate a style that is concise and easy to read. 2. Simplicity. Legal writers should reduce complexity whenever possible, giving readers only the details they need. 3. Aesthetics. Attorneys should cultivate their ear for language and aim to write engaging and pleasant prose. The word elegance, defined by the Oxford English Dictionary as harmonious simplicity and tasteful appropriateness in the choice and arrangement of words, captures these values. This book collects insights and techniques that have resonated with me and my students. I've shared these lessons in continuing legal education seminars and writing courses at the UCLA School of Law and the LMU Loyola Law School, and I use them daily in my litigation practice. While mainly offering practical guidance for attorneys and law students, with chapters 7 through 9 relating specifically to litigation, elegant legal writing can help anyone who writes for professional audiences. Attorneys who write well project an image of expertise and win more cases. Studying prose techniques will make you a better advocate. Part 1. Style. 1. Core principles of legal writing. 1.1. Adopt a growth mindset. 1.2. Commit to improving your writing skills. 1.3. Aim to write prose that is clear, readable, and efficient. 1.4. Learn the principles of readability. 1.5. Distinguish rules from guidelines. 1.6. Balance competing values in writing tasks. 1.7. Include only relevant details and put them in context. 1.8. Motivate readers by showing how your document will help them. 1.9. Think like a teacher. 1.10. Avoid common audience-related mistakes. Lawyers should strive to write documents that are clear, easy to understand, and enjoyable to read. Lucid legal writing can lead readers to forget that they are reading for work instead of pleasure. 1.1. Adopt a growth mindset. The way you think about writing and learning will influence how much value you gain from activities such as listening to this book, taking legal writing seminars, or receiving detailed feedback on a draft. Psychologist Carol Dweck used the term growth mindset to describe a set of positive beliefs that make learners more resilient and open to new ideas. This section discusses 3 beliefs that can put you in the right frame of mind to improve your writing skills. Belief number 1. Studying writing is a worthwhile use of your time. Identify why writing skills matter to you. If you believe that improving your writing will make you a better lawyer and help you obtain better outcomes for your clients, for example, then you'll be more receptive to feedback and new ideas. For lawyers, writing is not just one skill among others, on the same footing as questioning techniques, substantive legal expertise, or negotiation savvy. Although a few attorneys may be so good at trial advocacy that no one cares whether they can write, such cases are rare. Most legal work consists of written communication and advocacy, so the ability to write competently is a prerequisite to success as a lawyer. Attorneys who go further, who learn to write artfully and persuasively, can earn professional respect unavailable to most peers and competitors. Belief number 2. However strong your writing, you can always improve. Most attorneys, because of self-selection and years of education, already have the language background, intellect, and knowledge to write at least passable legal prose. Many are strong writers who still have room to grow, while others need to improve more than they realize. Although attorneys should write with a sense of confidence, don't allow your ego to make you resist feedback and miss out on learning opportunities. Working to improve as a writer is analogous to learning a musical instrument. There is no finish line. If writing well matters to you, strive to get better at it every week. Belief number 3. Writing skills can be taught and learned. Writing is too often spoken of as an innate ability rather than a set of skills that can be studied and practiced. Skilled writers draw on their writing experience, knowledge of technique, sense of rhythm and sound, empathy with the audience, experience telling and listening to stories, and intuition for language as honed by years of reading. All these can be cultivated. The techniques that make some legal briefs more readable and persuasive than others can be taught, as this book demonstrates. 1.2. Commit to improving your writing skills. There are 4 main ways to improve as a writer: studying writing craft, reading widely, practicing often, and seeking feedback. Study writing craft. Legal writing courses usually focus on research and brief structure rather than prose style, so many lawyers never study composition principles like those taught in this book. You can seek out opportunities to learn more about writing by attending continuing legal education classes, hiring an editor or writing coach, and reading books like this one. Law firms should integrate writing instruction into their practice by bringing in writing experts to give seminars, hiring editors and writing coaches, encouraging candid feedback, and otherwise investing in their attorneys' writing skills. Read widely and often, with an eye towards style as well as substance. Read widely to tune your ear for language. Don't restrict yourself to legal materials. Make time for literature and general nonfiction, too. Although it's not easy for attorneys to make time for pleasure reading, it may help to see reading time as a way to refresh your mind and improve your writing skills by exposing yourself to fresh language, new ideas, and unfamiliar vocabulary. Consider subscribing to sophisticated generalist publications about politics, arts, and culture. Outlets such as The New Yorker, The Economist, Harper's, The New York Review of Books, and The Atlantic. For contemporary literature, I recommend The Paris Review and Poetry. For daily news, The New York Times. These periodicals cater to highly educated readers, so they hire the best writers and editors they can find, and their articles usually show a painstaking attention to language and style. Reading literature, even by listening to audiobooks, will improve how you think and write. Literary works, classic or contemporary, have been thoroughly edited. Their writers have scrutinized every paragraph, sentence, and word with an eye towards such matters as rhythm and imagery. Think about their choices and allow them to develop your sensitivity to language. Train yourself to read with an eye to both content and style, attending to not just what is being said, but how the writer says it. Notice what you like and dislike about different styles, and consider how you might use the techniques you observe. When reading an article that aims to persuade, try to understand the rhetorical and argumentative moves the writer makes. See writing tasks as opportunities for deliberate practice. Writing well requires practice. In general, the best writers are those who regularly devote significant amounts of time to writing. Also, each time you perform a particular type of writing task, drafting discovery requests or a complaint, for example, you'll get better and faster at that task. Psychologist Anders Ericsson argued that expertise is built through deliberate practice. One becomes a better writer by writing a lot while consciously working to improve one's craft. You can think of each writing task as an instance of practice that will, if deliberately performed and closely attended to, help you improve as a writer. When you finish a project, don't put it away immediately. Instead, reflect on what you could have improved about the document or your writing process. Compare early drafts to the final version to make yourself more aware of areas for improvement, and note these for future reference. Seek out editing and feedback. Many lawyers dread feedback. Some see extensive edits as a personal criticism of their lawyering and attention to detail. This sensitivity is understandable given the centrality of writing in legal practice. It is hard to be both a poor writer and a good lawyer. And for associate attorneys in their first few years out of law school, eager to meet a firm's expectations, it can be hard to see a supervisor's extensive edits as something other than a message of displeasure with the quality of the associate's work. But to improve as a writer, you must overcome any aversion you feel toward editing. A good editor's suggestions say something about the draft, not its author. When law firms make candid feedback and thorough editing standard practices, attorneys are more likely to see colleagues' edits as a routine and non-threatening step in the firm's quality control procedures. 1.3. Aim to write prose that is clear, readable, and efficient. Whoever knows he is deep strives for clarity. Whoever would like to appear deep to the crowd strives for obscurity. Friedrich Nietzsche, The Gay Science. Despite decades of effort by legal writing experts, there remains a misconception that legal writing should be difficult to read. Lawyers tend to adopt the language of their community. Law school introduces legal Latinisms, for example, arguendo, redundant doublets, for example, terms and conditions, and circumlocutions, for example, the above-captioned case, to students, who then use these devices in their own drafts. At first, the legalese bolsters the new lawyer's self-identity as a member of an impressive profession, and then its use becomes an unconscious habit. Some lawyers believe that legal prose must be complex because the law is complex, but the opposite is true. A lawyer's job is to chart a path through complexity, not add barriers to understanding. The three related concepts of clarity, readability, and efficiency are the main virtues that distinguish a strong legal prose style. Clarity refers to how well the text conveys your intended meaning. Readability refers to how easy it is to read and parse the text. Efficiency refers to how much relevant information the text conveys in proportion to its length and difficulty. Other stylistic defects, awkward idioms, clumsy rhythms, and so on, will be forgiven if the text is clear and easy to read. Additionally, style, substance, and persuasion are intertwined. A clear prose style correlates with clear thought. Many lawyers resist this advice. Some confuse legalese with specialized terms of art, which carry an established meaning that is cumbersome to express in ordinary language. Or they fear that modernizing the boilerplate language used by their predecessors might put their clients at risk. It feels safer to stick with tradition. But stylists and legal writing scholars advocate a plain language style that is, as Jacques Barzun puts it, simple and direct. Given their unanimity, one would expect the plain language style to be the norm in legal writing, but that is not the case. Although plain language principles are increasingly evident in briefs filed by litigators at elite firms, most legal writing remains turgid, boring, and painful to read. It need not be so. 1.4. Learn the principles of readability. Almost all the tips and strategies in this book aim to make your legal prose more readable. Unnecessarily complex prose taxes the reader's memory, attention span, and motivation, so it's less likely to be carefully read or understood. Judges can be persuaded only by arguments they understand. This section describes some high-level concepts associated with readability. Even a passing familiarity with these will help you absorb this book's recommendations and develop them into automatic reflexes. Some texts are more readable than others, requiring less exertion from the reader while conveying similar information, because they impose less of a burden on the reader's attention and short-term memory. Unnecessarily complex prose imposes a greater cognitive burden on the reader. All readers have limited time, energy, attention span, and appetite for obligatory reading. These constraints are especially acute for trial court judges, who must distribute their scarce time and energy across all the active cases in their dockets. Along with extrinsic constraints such as limited time, all readers have cognitive constraints that limit their ability to process written text. Here are some concepts to know. Working memory. The reader's understanding of a sentence depends on the context created by the preceding text, some of which the reader holds in their working memory. A reader's working memory can only hold about 5 linguistic objects at once. If the writer takes too long to complete a thought, they may lose the reader before conveying the intended meaning. Attention span and motivation. Readers are more likely to understand and remember something they read if the writer sets out to be useful and makes their point before the reader's attention drifts. Relatedly, if a judge senses that your brief will not help them reach a sound conclusion, they may stop reading. Task switching. Readers can focus on only one stimulus or processing task at a time. There is no such thing as multitasking, only rapid switching between tasks. Switching focus from one processing task to another has imperceptible cognitive costs. It slows readers down and interferes with comprehension. Inefficient task switching occurs when the reader loses track of what the document is talking about and must backtrack. Integrating information and resolving uncertainty. When confronted with new information, readers try to integrate it into what they already know. Relatedly, readers try to resolve uncertainties as quickly as possible. This applies to macro-level tasks, such as grasping an argument, and micro-level tasks, such as identifying what a pronoun refers to. The scarce resources of attention, energy, and motivation are interrelated. They play a central role in determining whether your brief successfully conveys your argument to an overworked reader. 1.5. Distinguish rules from guidelines. Most writing advice should be prefaced with the qualifier, all else equal. All else equal, for example, shorter words and sentences are more efficient than longer words and sentences. Active voice constructions make for livelier prose than passive voice constructions. Palatino linotype is a more readable font than Times New Roman. But other considerations often warrant a departure from these guidelines. Perhaps your local judge mandates that briefs use the typewriter-style font Courier or some other design blunder. You'll have to follow court rules. If such a misguided edict comes from your supervising partner instead of a judge, send them a copy of this book. Some lawyers resist writing advice on the theory that what constitutes good prose is a matter of personal preference. They once learned that 2 spaces after a period are better than 1, so they disagree with the advice to use 1 space. Their high school teachers told them to never split infinitives, so they think this sentence contains a grammar error. Their first bosses after law school made them write headings in all caps, and they'll do so until they retire. These mindsets are just forms of resistance to learning something new. Most writing and design experts agree there should be only 1 space between sentences, so it's indefensible to stick with the 2-space approach, unless you have reason to believe that the experts are wrong. Writing advice occupies a spectrum. On one end, there are established prescriptive rules that ought not to be broken. On the other, there are matters debated by experts who study prose for a living. If you're unsure where along the spectrum a recommendation falls, here is a test. Can you find a writing stylist who espouses the opposite view? Composition is a craft, not a free-for-all in which all opinions hold equal weight, so books about style often have overlapping recommendations. This book's guidelines about writing mechanics align with those of other stylists and with the plain language philosophy that legal writing professors have promoted for decades. When I disagree with widespread advice, as I do with respect to footnotes, I note those disagreements so the reader can consider other approaches. Composition is also an art. There are an infinite number of variables that can influence how a writer expresses a thought. Most writing advice is therefore necessarily tentative and general. It is ideally rooted in a combination of expert opinion, readability studies, principles of logic and design, and intuition shaped by a lifetime of reading and writing. 1.6. Balance competing values in writing tasks. Writing guidelines often conflict, requiring the writer to evaluate trade-offs and choose between different ways of expressing the same idea. This process can be guided by a sense of how to prioritize the values underlying different pieces of advice. If you're writing a discovery motion, you'll have different priorities than someone writing a poem. Aesthetic considerations, such as pace and rhythm, matter even in litigation writing, but they are less important than complying with court rules and making the judge's job easier by using a plain language style. Here is a suggested ranking of values for litigation writing. 1. Fulfilling your ethical duties, including the duties to be competent, to avoid misstating the facts or law, and to avoid misleading the tribunal. 2. Filing the document on time. 3. Following the court's rules so the clerk doesn't reject your filing and you don't lose the motion on a technicality. 4. Clearly explaining your point. 5. Persuasively arguing your point. 6. Avoiding blunders, such as spelling and grammar errors. 7. Making the filing as short and readable as possible. 8. Holding the reader's interest and motivating the reader to continue. 9. Making the text pleasant to read by using effective style techniques. 10. Making the text appear professional and impressive by following sound layout, design, and citation formatting practices. For other forms of legal writing, most notably contracts and statutes, the need to avoid ambiguity and rule out competing interpretations often overrides other values. 1.7. Include only relevant details and put them in context. Context is critical in writing. The advice to write as you speak is unhelpful because spoken interactions occur in a live social context. That context lends meaning to vague and nonverbal expressions, helps resolve ambiguous references, that is, makes clear what someone is talking about, and creates an atmosphere of shared meaning. Written documents, by contrast, usually need to provide context. Once the writer provides a context, a mental world they invite the reader into, they can leave more to implication and rely more on the reader's cooperation. Context gives meaning to details, determines their importance, and shows how they interrelate. Your document should include only details that matter, and those details' relevance should be made clear. A reader should never be left to guess how details fit into a conceptual structure and work together to convey meaning, tell a story, or make an argument. 1.8. Motivate readers by showing how your document will help them. Motivation is a critical determinant of a reader's attention span. We pay more attention to text that strikes us as interesting and relevant to our purposes. Most readers, when they pick up an unfamiliar document, subconsciously ask themselves, "Why should I spend time reading this?" This is especially true of busy readers such as lawyers and judges. You need to reassure these readers immediately that they should invest their time and energy in your document. To do so, try to see the text from the reader's perspective and think about the problem they need to solve. At the start of the document, show that you understand that problem. Tell the reader what solution you've found and provide a roadmap that previews the most important reasons your solution is correct. 1.9. Think like a teacher. To put yourself in the right frame of mind for legal writing, it helps to think of yourself not just as an advocate, but as a teacher. In a risk analysis letter, you teach the client the information they need to make an informed decision about how to handle a legal matter. In a motion, you teach the judge the rules and analytical moves that, when applied to the relevant facts, lead to the conclusion that your motion should be granted. No one is likely to be persuaded by a text or argument they do not understand, so you must impose order on the raw material of your case, the applicable law, facts, and record, to help the judge grasp the parts that matter. Only then will you be ready to persuade. Legal documents should adjust to the reader's background knowledge. In general, assume that your reader is a well-informed member of the legal community who is a bit rusty on the specific topics you are covering. Don't waste the reader's time with information they already know. Here's an example from an appellate brief of what to avoid. Standard of review. The standard of review refers to how the appellate court conducts its examination of the matter on appeal. Morrison, 538 PA at 131. Every appellate judge knows what a standard of review is. You should say which standard applies in your case. For example, abuse of discretion or clear error. But you don't need to explain the concept of a standard of review. 1.10. Avoid common audience-related mistakes. Writing with your audience's needs in mind can help you avoid some bad habits that abound in legal writing. Avoid research dumps. If you're writing a brief or memo, don't try to include everything you learned while researching.
Sample complete. Ready to continue?